Good afternoon, everyone. We'd like to welcome you and thank you for joining our webinar, Posting Compliance and Lawsuits, Why You Should Care. A quick note before we get started. Please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns. We will try to answer as many questions as we can about the material presented via follow-up emails after the presentation. And without further ado, here is Ashley Kaplan, our in-house senior employment law attorney. Ashley has been practicing labor and employment law for more than 20 years, representing employers in a variety of matters, from discrimination and harassment litigation to defending FLSA class action lawsuits. Here at Postregard, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing compliance solutions to meet our customers' diverse needs. And as a special offer to our attendees today, Ashley will be available to set up a complimentary personal consultation about your specific posting compliance needs. If you are interested, please indicate that in the question box and we will contact you to set it up. And now, here's our presenter, Ashley Kaplan.
Thank you, and welcome everyone. The goal of today's webinar is to share some important information about labor law posting compliance, the risks of non-compliance, and why it's important to get it right. So we get a lot of questions about the penalties for being out of compliance. What can really happen if you're missing a poster or you have an outdated poster. So we're going to go over exactly what can happen and what is actually happening out there in terms of fines, penalties, and lawsuits around posting compliance. And that's something a lot of people don't even realize. It's not just government posting fines that you need to be aware of. Employee lawsuits are the real danger, and labor law posting compliance can have a direct impact on your liability in any kind of employment dispute or employment litigation. The government fines are pretty significant too. They can really add up, especially now that they've recently been increased, which we're going to talk about today. But when it comes to employee disputes and litigation, the damages can be even more devastating than government fines. So it's important to be aware of both kinds of liability. We're also going to cover what posting compliance really means. And it's not just a matter of having the most recent posters up on the wall. There may be posting requirements that apply to you that you're not even aware of. And most employers, most businesses, whether you're handling posting compliance yourself in-house or using another poster provider, most employers aren't even aware that they're missing a lot of mandatory labor law posters that are required for their business. So some examples, this could include mandatory posters that have to be posted in Spanish, even if you have no Spanish-speaking employees. It could include city or county labor law posters, posters for job applicants, and then there are also additional posters that are required if you have any government contracts. So these are all areas that a lot of businesses still overlook. So today we're going to go over the posting compliance basics, what you need to know to make sure your labor law postings are complete and fully compliant. And I'll actually highlight 5 common mistakes to watch out for. And I'm also going to explain why it matters, the penalties, the liability, and the risks associated with noncompliance. And then we're also going to go over a solution by Postregard that will help you manage all the posting requirements that apply to your business and keep you on the right side of the law when it comes to posting law compliance. So hopefully after the presentation you can cross posters off your list of worries and focus on other essential areas of HR, compliance, and really just managing your workforce. I know there are plenty of other new laws and HR challenges out there that I'm sure are keeping you busy enough already. So first, let's start with a basic understanding of labor law posting compliance, and then we're going to go into the details about what it takes to be in full compliance with today's requirements and why it matters. So posting compliance today is more complex than ever. As most of you probably know, all businesses in the U.S., if you have one or more employees, businesses have to post both federal and state employee notices. And on top of that, if you're in a city or county with mandatory posting requirements, you also have to post local postings. So just backing up, there are currently 6 mandatory federal posters, and I've listed them here on this slide. First, there's the posting issued by the EEOC, the Equal Employment Opportunity Commission, and this one covers anti-discrimination provisions and protected characteristics under federal law. Next is the OSHA posting, and this one highlights important provisions of the Occupational Safety and Health Act. Next on the list is the FMLA. This is the Family and Medical Leave Act, mandatory posting. Then we have USERRA, which stands for the Uniform Services Employment and Reemployment Rights Act. And this notice covers reemployment after military leave, anti-discrimination provisions, and then other issues like health insurance affecting veterans and those serving in the military. Then there are two more on the list, and both of these actually had mandatory updates in 2016 at the end of the year. I just wanted to point that out. First, there's the FLSA, the Fair Labor Standards Act posting, and this one notifies employees about the federal minimum wage rate, overtime rules, and there's a lot of information on there about child labor laws, federal child labor laws as well. The mandatory update at the end of 2016, it was actually issued, I think, in July or August, incorporated a few major changes. The changes included information about misclassification of independent contractors, not the exempt, non-exempt classification issue, that's separate. But this poster update had information about misclassifying independent contractors. Also included information about mandatory breaks for nursing mothers, and also the increased penalties under the Civil Penalties Inflation Adjustment Act. And that's a law that actually increased the penalties for various violations under federal employment laws, including posting violations, which we're going to talk about in a minute when we go over the risks of noncompliance. But that was part of the reason why this poster had to be updated, because they were addressed on the poster. And then finally, there is the EPPA, which stands for the Employee Polygraph Protection Act. And this one lets employees know the rules around lie detector tests in employment. And this poster is mandatory, of course, even if you don't use lie detector tests. I get that question a lot. And the reason this poster was updated in 2016 was also to reflect changes in the penalty structure under the Civil Penalties Inflation Adjustment Act, just like the FLSA poster. And like I said, that law actually affected penalties under most federally enforced employment laws. But these two posters were the only ones that had mandatory updates because of it. You know, each agency operates independently, so sometimes there's not a lot of consistency across agencies or, reflected in the posters. Okay, so those are the federal posting requirements. And then on a state level, there are additional mandatory postings that are required for every business. Depending on what state you're in, this can add up to 15 additional posters. So that would be a total of up to 21 federal and state postings per location. And this area of compliance on a state level is definitely becoming more complex and difficult to manage over the years because more and more laws are being passed on a state level giving employees protection in employment. And whenever there's a new law, there's a potential poster update or in some cases a brand new poster, a brand new law that never existed before. Even as we see laws being rolled back or changed or tweaked in any way, and not necessarily giving employees more protection, the result is usually a poster change or mandatory poster update. These state posters cover topics typically such as state minimum wage rates, fair employment, unemployment insurance, workers' compensation, state laws around smoking in the workplace, paid sick leave, child labor, and then some of the newer areas that we're starting to see like human trafficking, expanded family care rights, and even electronic cigarettes in the workplace. So like I've said, on top of this, you may have additional posting obligations if you're in certain cities or counties with their own posting requirements. And this is an area where we've really seen a lot of growth. There's been so much growth in terms of the number of new city and county postings being issued and also the number of updates to these posters. And that's really taken off over the past couple of years. And, of course, that's what we're going to be focusing on today. Like I mentioned, you can have up to 9 additional postings just for city or county compliance. The city with the most, the one with 9 postings, is actually San Francisco, and I'll get into the specifics on that. But there are other cities and counties with multiple posters as well. It's not just San Francisco. So as you can see, there's a lot to keep up with to stay in compliance. And then on top of this, if you're in certain industries or if you have any government contracts, federal government contracts, or if you have a significant number of employees who are not proficient in English, then there are even more mandatory posting requirements that would apply to you. Federal contractors, for example, now have up to 15 additional postings, depending on what kind of contracts you have, and in some cases the amounts of the contracts. But it could be up to 15 additional postings on top of what we're talking about. Another thing that a lot of people are not so familiar with is that there's not a one-stop shop for free government posters. There's not a central place or a website where you can get all the free government posters you need all in one spot. There's actually, across the nation, there are actually 175 different agencies that are responsible for issuing the posters and enforcing the posting laws. And that's just on a federal and state level. And right now there are about 370 different mandatory posters on a federal and state level. And that, of course, doesn't take into account all the additional local postings, the city and county postings that I just talked about, or any of the other industry or federal contractor requirements. So in any given state, in just one state, managing posting compliance for an employer with one location in one state could require you having to go to up to 9 different agencies to get the required posters, just for federal and state law compliance. And then on top of that, there are also about 22,000 cities and counties in the U.S., each with their own governing agencies and ordinances to monitor. So luckily, I want to be clear, not all cities and counties have posting requirements today, but a lot of them do. And like I said, we're seeing this number grow every day. And none of these agencies, whether it's federal, state, or local, these agencies do not have work share agreements or sister agreements where one agency provides all the posters that another agency requires. In some cases, some agencies do a pretty good job, and they'll try to help out, and you'll see some crossover on their websites. But there simply is not a one-stop resource because, like I said, each poster is issued by different agencies, and they're governed and enforced by different rules and regulations. So you're not going to be able to come across a complete list. And there's certainly not, when we talk about the city and county postings, there's no crossover between federal and state, but certainly not on the city-county level. The local agencies really operate on their own, apart from state and federal. So adding to this complexity is the fact that posting changes are also on the rise. Our legal team here at Postregard monitors and tracks all the poster changes on a daily basis, and on average, we see about 150 state law posting changes a year. And every time there's a posting change, our legal team reviews the underlying laws to determine if it's mandatory or non-mandatory. We also look into a lot of other factors, to research if there are mandatory size, font, color requirements, foreign language requirements, industry-specific requirements. And just in looking at whether a change is mandatory or non-mandatory, at least half of the state law changes that come through do require a mandatory update or immediate replacement of the posters. And then on a local level, sometimes we get 2 or 3 mandatory changes a week in the same week. It really just depends. We do see even more mandatory poster changes near the end of the year when a lot of states and cities are raising their minimum wage rates. But poster changes happen all year long. So another problem is that the government agencies don't notify businesses when these posting changes occur. So this can be really difficult because the posting requirements and the notice of change, the notices of changes, can be buried on different agency website pages. And a lot of times the old posters remain up on active website links with no further information, even though they're not compliant. You really just have to search around and do your research. They don't always redirect you to a new page or a new poster. And then sometimes the posting guidelines can be buried in statutes, regulations, or even case law. It's not always just right there on an agency webpage where you would find the poster. So it can be difficult to find posting changes and also difficult to interpret whether the updates are mandatory with compliance deadlines or just cosmetic changes that you can ignore. So now we're going to talk about the risks of noncompliance and why it's so important to make sure you have all the current postings and your posting display sites are complete and up to date. So I get a lot of questions on this, and I hear two things a lot. The first is that government posting fines are so small that it doesn't really matter if we get caught. And the second thing I hear a lot is, well, there are no poster police out there, so how would I ever get caught anyway? So I'm going to address both of these misconceptions really briefly. First, when it comes to the amount of the fines, the amounts are actually pretty significant. And they can certainly add up if you have the same types of violations at multiple locations. The penalty structures are per location or per violation, so they can add up. In the statute for the regular federal postings, just talking about federal postings, government is now authorized to fine up to $33,000 per location for posting violations. It's actually $33,486. And that's based on the most recent increases that just went into effect in January 2017. And government fines typically are imposed either for missing posters or outdated or old posters. And as I mentioned when I was talking about the federal poster requirements on the very first slide, this penalty amount first increased as part of the Civil Penalties Inflation Adjustment Act. That went into effect in 2016 and caused those two mandatory poster updates. The federal fines for posting violations were only around $17,000 combined. So that's a pretty significant increase. It's almost doubled. And the Civil Penalties Inflation Adjustment Act actually calls for increases going forward each year to keep in line with the inflation rate. So they were increased again in January 2017, and they're expected to gradually increase going forward each year. So that's for the federal postings. On a state and local level, the government posting fines are typically between $100 and $1,000 per violation. Each posting has its own fines attached to it, so they're really all over the place. There is a California poster, I think, that carries a heavier fine. I think it's $7,000. But in general, this range here on the slide is pretty accurate. Like I said, every agency and every posting law is different, but in my experience, I typically see state and local fines come in the range of about $500 or up to $750 per violation. Okay, the second misconception I mentioned is that there are no poster police out there, so there's really no need to worry about government posting fines. Well, the reality is the federal government rarely sends out representatives to businesses just to enforce posting laws. That's true. We actually have seen this on a state and city level where there have been poster sweeps by enforcing agencies or even the state attorney general. But on a federal level, government posting fines typically are assessed because the agency's on your premises for another reason. It could be an immigration-related issue. It could be an OSHA inspection, an EEOC on-site investigation, or even more commonly, just a Department of Labor audit that was triggered by some kind of employee complaint, a current or former employee. And the complaint or the investigation is usually completely unrelated to the posters, but of course the agencies always check posting compliance as part of any on-site visit. It's one of the first things in their field operation handbooks to look for. So these government posting fines can really add up, especially if you have multiple posting locations and similar mistakes across the board. But the biggest danger with posting violations, like I mentioned earlier, is related to employee lawsuits, employment litigation. And there are a few different ways that posting compliance comes into play with employee lawsuits. The first and probably the most significant is when it comes to the statute of limitations. And the statute of limitations can be an employer's best friend. As an employment litigator, I like to consider it an employer's best friend because it's the defense that allows you to have a claim stricken or dismissed because it was filed too late. And the statute of limitations, for example, for a federal discrimination claim is 300 days. For a Fair Labor Standards Act case for overtime or unpaid wages, the statute of limitations is 2 years. So typically, if you get a claim from a former employee or an existing employee for a violation that occurred outside of that time period, you can move to have that claim dismissed and avoid all the legal fees and all potential liability for the lawsuit. And that's true even if there was a valid claim. If it's filed too late, you can have that claim dismissed. However, if you have a posting violation, missing or outdated posters, courts have begun to publish more and more decisions saying that if an employee didn't have notice of their rights because the posters weren't up, that the statute of limitations is extended or tolled, and you cannot use it as a defense. So we've seen cases where normally an old claim would have been dismissed, but the court allowed the plaintiff to pursue the claim, and it ended up in a six-figure judgment just because the posters were not up on the wall. So the statute of limitations not only limits the time period when someone can sue you, but if you think about it, it also limits your exposure to damages, like how many years back you have to pay for a back pay award, for example. So this can be a big issue in any case where you're facing potential damages for back pay. Back pay is where an employee's claim includes damages for lost wages going back in time, which is really common under all the federal and state employment laws that are represented in the posters. It's common in any lawsuit alleging any kind of wrongful termination or unfair pay practice, whether it's brought under Title VII for discrimination, whether it's the FLSA for time and pay violations, the Americans with Disabilities Act, the Family and Medical Leave Act, or just about any federal or state employment law that gives employees the right to sue in civil court. It's very common. So take, for example, a case brought under the Fair Labor Standards Act for overtime pay. If you consider all of the employees affected by an overtime policy, let's say you had a faulty overtime policy, or if you had a misclassification of a certain job position as salaried exempt when it shouldn't have been. If you consider all the affected employees, it can make all the difference in the world to cut off your back pay exposure to 2 years. So without the statute of limitations in that case, you could be on the hook going back for years and years with liability for every employee in that particular job position who has been misclassified, if it's a misclassification, for example, or every hourly employee that was paid incorrectly under a faulty overtime policy, everyone that was subject to that policy or that practice. So that can really add up quickly. And obviously posting compliance is worth the effort when you consider this level of risk, especially given the growing number of employment lawsuits we're seeing every year. Employment lawsuits continue to grow. They're not going away or diminishing it by any means. Last year, in fact, lawsuits alleging violations of the Fair Labor Standards Act reached an all-time high, and actually, this is just for FLSA lawsuits in civil court, they actually produced more rulings than any other type of workplace class action. The most litigious states, again, a few of these are no surprise, were California, Florida, Massachusetts, New Jersey, New York, and Pennsylvania. And just another stat here, reports show that employers paid out over $250 million in judgments as a result of private lawsuits brought under the FLSA. And that doesn't include all the cases that were settled or cases that were brought by the Department of Labor. We're just talking private FLSA lawsuits. So that's the FLSA. Discrimination lawsuits are also on the rise. And based on my experience defending this type of litigation, Title VII cases or similar state law claims, I can tell you that attorney fees alone are really costly, just to defend these kinds of claims, even if you ultimately prevail on the merits of the case. So that's why the statute of limitations defense is so important. Employers and businesses spend thousands of dollars just defending a claim, even if there's no legal validity to the allegation. So even if you haven't committed a violation, just your attorney's fees alone climb up to the six figures. There's a recent report that shows in a typical discrimination case, an employer spends an average of about $250,000 in attorney's fees if the case goes to trial. And then, of course, in addition to attorney fees, you're also facing the potential liability for the alleged violations, and an employer could end up paying millions to satisfy a legal judgment for a claim that, like I said, should never have been even brought if they had been able to assert the statute of limitations defense. They would have never been forced to pay to even defend that claim. There are actually a lot of published cases where this has occurred, so we've put together a white paper. If you're interested, we have a detailed white paper with examples of court cases. Some of the examples that I've referred to are in there as well. So if you're interested in reading more about the actual cases and judgments and everything, just let us know that in the question box or send us an email, and we'll be happy to send that to you after the presentation. We can email that to you as a follow-up. Another way that posting compliance comes into play with employee lawsuits is as evidence of bad faith. And all of the different federal and state employment laws have different standards, different legal standards, where the concept of good faith or bad faith affects the employer's potential liability, where a showing of good faith can reduce or eliminate damages against you, or a showing of bad faith can increase or inflate damages against you. Some examples under different terminology, different legal standards, but under Title VII for a federal discrimination claim, you can be assessed punitive damages. Under the Family and Medical Leave Act or the Fair Labor Standards Act, you can be assessed double damages or what are called liquidated damages. So they're all different in terms of the names and the standards. But depending on the law, courts look at various factors to determine if a company acted in good faith or bad faith for purposes of damages. So some of the things courts look at are, whether you had written policies in place, whether you trained your managers on compliance issues, what steps you took to prevent and respond to violations, just your general culture toward compliance. And now we're seeing more and more cases where posting compliance is specifically coming in as a factor that the courts are looking at when they're making these assessments of good faith and bad faith. Did the employer comply with the basic notice and posting requirements? Also, with the FMLA, the Family and Medical Leave Act, the current regulations actually mention posting compliance as a recognized cause of action if noncompliance, failure to post, results in any kind of interference with someone's rights. So failure to post the required notices under the FMLA, if it results in some kind of injury or harm, for example, if an employee didn't have the right information to know how long they had for leave or what procedures were in place for requesting time off or returning to work. And if that was caused by the absence of the posting, then the employer can be on the hook for that employee's back pay and all the other damages suffered by that employee under the FMLA. So, if the employee ended up getting terminated, that could mean back pay, front pay, reinstatement, and so on, all the damages available under the FMLA. By the way, that white paper that I mentioned also has some examples of these kinds of cases as well, FMLA cases, good faith, bad faith cases, everything that we've gone over. So needless to say, it's important to make sure you're on the right side of the law when it comes to posting compliance. It's simply not worth the risk to cut corners knowing these risks and the potential liability involved. So now we're going to talk about what it takes to be in complete compliance. And in addition to keeping track of all the changes and staying current, all the basics that I've already gone over, there are other aspects of posting compliance that you should all be aware of. I'm actually going to highlight 5 common mistakes, 5 areas that businesses commonly overlook that, where I still see problems, where businesses make mistakes when it comes to posting compliance. And as we go through these, I'm also going to be telling you about a solution that addresses all these issues for you, and that is Postregard compliance protection. So first, very briefly, I realize that some of you may not be Postregard members, so I wanted to give a really quick overview of how Postregard works, how the program works, And then you'll understand what I'm talking about, what I mean throughout the presentation as I refer back to it. So Postregard was developed because of the complexity involved for businesses when it comes to keeping up with all the mandatory posters, keeping up with the rate of change, all these mandatory changes, and also because of the severity of the penalties for noncompliance. The way the service works is upon your initial enrollment, we start you out by sending all the mandatory federal, state, and local labor law postings to each of your locations. And all the mandatory posters are combined and printed in a condensed laminated format. And that's to help save wall space, but also to ensure durability and to protect the posters from being ripped or torn or covered up, which is a legal requirement. So that's to help ensure compliance. Once you get your initial postings, we take care of everything from there. Our in-house legal team monitors the posters daily for changes, and whenever there's a mandatory update or a new posting that's required, whether it's federal, state, or local, we automatically notify you and immediately send you the new posters at no additional charge. So that's an ongoing thing. No matter how many changes there are throughout the year, we're researching them and automatically sending replacements whenever there are mandatory changes. And Postregard also provides a 100% guarantee against government posting fines. So what that means is if you're a Postregard member and you receive a government posting fine when you've properly displayed the most recent versions of our posters that we sent you, we take full responsibility for the fine with no limitations. Something else worth mentioning here, to help further protect you against damages and lawsuits, we also provide complete record keeping. So we maintain up to 5 years of records, and we provide our customers regularly with all the evidence and data that you need to respond to any kind of request in litigation, in discovery, or in any government investigation. So, that's to help prove that you were in compliance when it comes to all the posting laws applicable to your business, what posters were required for what locations, and that you were in complete compliance. Okay, now let's jump into some common violations and what you need to be aware of to maintain 100% compliance with these mandatory posting regulations. Like I said, I'm going to highlight 5 compliance essentials, and these are the areas where I still see so many mistakes and so many businesses that just aren't aware that these requirements exist. The first is when it comes to foreign language posting requirements. And this applies to everyone, every business, even if all of your employees are proficient in English. So there are actually 22 states right now, plus Washington, D.C., where you are required to post certain postings, certain labor law postings, in Spanish. So you're required to post in both English and Spanish, regardless of your workforce demographics. That means even if you don't have any Spanish-speaking employees on your staff, and everyone's proficient in English. In these 22 states in Washington, D.C., there are actually 47 individual postings that have to be posted in English and Spanish. So it's not every posting in those states, it's certain postings in those states. And then a few states, we've talked about English and Spanish, but a few states go even further and have requirements for other languages, and not just state law posters. We've especially seen this on a local level, where we've seen up to 11 different languages required. Russian, Japanese, Arabic, Mandarin, and Creole. It just really depends on the poster and the agency's guidelines for that location. And then just a side note, in Puerto Rico, all of the postings have to be displayed in Spanish, and English is just a best practice. Spanish are mandatory. So this is the list of the 22 states that currently require certain postings to be displayed in Spanish. Like I said, even if you don't have any Spanish-speaking employees. So the good news is, if you're a Postregard member, these postings are already included in your English service. And I know this can be confusing because it's called the English service, but we believe in order to make sure you're entirely in compliance, if this is something that's required for all employers, then it should be included automatically and not require any action on your part to let us know that you need it, to do your own research, or to make a decision about what you need to get. So they are automatically part of the basic English service at no additional charge, and that's to keep you in 100% compliance, in 100% compliance. So if you're in any of these states, there's really nothing to worry about when it comes to these postings if you have the Postregard regular basic English service. The postings already appear on your English panels in both English and Spanish. You may not have noticed that, but they're already on your English posters. Now, if you do have locations with Spanish-speaking employees, then there are some additional requirements that you need to know about. So things change a little bit when it comes to your locations with a significant number of Spanish-speaking employees. That's the legal standard. So first of all, when it comes to the federal poster, the federal combination poster has 6 unique postings on it. If you have a significant number of Spanish-speaking employees who are not proficient in English at a location, you need to post the federal combination poster in both English and Spanish. On a state level, there isn't a requirement that's written into law that says you have to post every poster in both English and Spanish, even if you do employ a lot of Spanish-speaking employees who aren't proficient in English. However, most employers who have to post the bilingual federal poster, because they do have Spanish-speaking employees, choose to go ahead and post all of the state law postings as bilingual in English and Spanish, just because it's a best practice. You know, it would just be difficult to explain in any kind of dispute why there was a choice made or a decision made that certain posters were posted in Spanish, but we didn't take the extra step to post all the mandatory notices in the language that we knew our employees would understand. So it's just a recommended best practice to post the state posters in Spanish if you know your employees don't read and understand English. There is one exception to this on a state level where it's actually mandatory to post in Spanish if you do have Spanish-speaking employees, and that's in Pennsylvania. So in Pennsylvania, employers who employ Spanish-speaking employees do have to post all of the state law posters in English and Spanish. Unfortunately, the agency doesn't provide a really clear definition of who this applies to. It's not like the federal standard with a significant number of Spanish-speaking employees who are not proficient in English. It's pretty vague, and it basically says that this requirement applies to all employers with Spanish-speaking employees in Pennsylvania. So to be safe, if you have Spanish-speaking employees in Pennsylvania, you should be posting both the federal and state, all the posters in both English and Spanish. For the other states, the full bilingual is just a recommended best practice. It's not mandatory. So one of the things about Postregard is that it allows you the flexibility to decide for each of your locations. You can decide on a case-by-case basis which ones need bilingual postings for federal, which ones need full bilingual, federal and state, and which ones can be covered by the English service. The English service, which already includes the mandatory ones if they are mandatory for all employers. And like I said, this designation can be different from location to location. Another common mistake is overlooking the local posting requirements that might apply to your business locations. And like I said, this is a fairly new trend we've been watching, and most businesses just haven't caught up with the laws around city and county posting compliance. There are a lot of cities and counties that now require businesses with one or more employees to post additional employee notices over and above the federal and state notices. On this slide, I've listed some of the major ones, and this isn't a complete list, but it covers the bigger ones that have popped up over the last couple of years. Now, just to be clear, again, not every city or county has posting requirements. But the number of cities and counties requiring employers to post labor law notices is really growing quickly. And this is really because local government jurisdictions are passing more and more ordinances giving employees rights and protections beyond what is already provided by federal or state law. Just like I mentioned before, that state laws, we're seeing more and more state laws giving employees protection beyond federal law. Now we're seeing more and more local laws giving employees protection beyond federal and state law. So our legal team is monitoring and tracking these local ordinances, and almost daily we're analyzing new legislation and ordinances that are coming out and doing the research to determine whether they require mandatory postings and adding them to our offering as they come up. In fact, this local piece is so important that Postregard has recently added resources to our legal team to make sure we're on top of everything. And now our basic service, the basic Postregard coverage, automatically includes city and county postings for all regions of the U.S. So our legal team has grown, and our attorneys and researchers are now continually monitoring all local ordinances and agency activity for more than 20,000 cities and counties to make sure all our customers are in complete compliance. So like I said, this local piece, local coverage, is automatically included in your basic service. So that means if you're a Postregard member, you're already getting these posters if they are required in your jurisdiction. There's nothing that you need to do in terms of requesting them or contacting us. They are being sent automatically. And by the way, just to clarify, these city and county postings have to be displayed in addition to the federal and state postings, even if the information appears to conflict. And this is something I get a lot of questions on. So just to give you the framework for how it works, states have authority to pass laws that are more generous to employees than under federal law. And local governments have authority to pass laws that are even more generous than under state law. So typically, you'll see that states have a higher minimum wage than federal law, and a lot of cities have an even higher minimum wage rate than state law. And these posters, by the way, cover much more than minimum wage. That's just the easiest way to illustrate. It could be paid time off or family leave. A lot of the same types of rights and protections that you see in the state law posters are reflected in these local posters. But as an employer, you have to follow the law that is the most generous to your employees, which would be the highest minimum wage rate, for example, or the longest period for medical leave. But when it comes to the posters, you still have to post all of the different posters. You follow the law that's the most generous, but you post all of the versions of the posters. Okay, now we're going to talk about federal contractor posting requirements. And this isn't really an industry-specific issue per se, because there are so many different types of businesses that may be covered by federal contractor posting requirements today. Everything from financial institutions to technology corporations to auto dealers and other retailers. And the specific posting obligations that you have as a federal contractor really depend on what types of contracts you have and with what government agencies. And then in some cases it may also depend on the amount of the contracts, not always. We've actually found that a lot of businesses with government contracts didn't even know they were required to post these additional notices. So this is an important takeaway, definitely something that you don't want to overlook, and also an area that's constantly changing and growing. So this is a list of the most common postings that are required for federal contractors. Again, like I said, it depends in a lot of cases on what type of contracts you have and sometimes the amount of the contracts. I'm not going to go into details on the specifics for each poster in today's presentation, but we do have a great white paper on this as well that covers each of the posting laws, and it'll help you determine which ones apply to you. So if you'd like that information, just send that request, use the chat feature or the question feature, or send an email, and we'll be happy to email that to you after the presentation. I can tell you that most federal contractors do have to post multiple posters from this list. So we do offer a full, all-inclusive service that covers all of these posters, existing ones and new ones as they come out, just to make it easier and to make sure nothing falls through the cracks. But these postings are also available individually. So the important thing to understand with these federal contractor requirements is that these posters change frequently, even more frequently than the regular federal posters that all employers have to post. And that includes changes to existing posters And then with federal contractor postings, we see a lot of new posters coming out as a result of executive orders. So updated posters and brand new posters. You'll see on this slide, you'll notice that I've highlighted a few of the recent changes here in red. But the point is that these do change a lot more frequently than the regular federal posters. So it really makes sense to get a service or some kind of solution that covers you for the existing ones when they change, and then also for the new ones as they come out. Also, the penalties for non-compliance can be even worse than what we discussed for the regular federal and state posters. If an employer doesn't comply with these federal contractor posting requirements, there are not only steep government fines, but you can also lose your government contract or your funding. It's typically written right into the contracts that the contract can be suspended or canceled just because of noncompliance with these posting requirements. The next big mistake I still see is overlooking your remote workers when it comes to posting compliance. And this is an area getting more and more attention because of the trend toward employing telecommuters, that continuing trend that we're seeing. So for years here at Postregard, the legal team has gotten questions about this. We've gotten customers who call up and they say, we have employees who work from home, and we need to know, we want to send them full laminated posters to their home address. So we've all kind of, laughed trying to imagine someone working from home and putting up these full-size laminated posters in their kitchen or on their bathroom walls, especially now that there are so many posters. And obviously that wouldn't work, and that's not required. Of course, you could do that, but it's not required. But it is kind of confusing because by law, you are required to provide the mandatory notices to all of your employees. However, the regulations don't tell us exactly how that's supposed to be done when it comes to home-based employees. So they do tell you you're required to communicate the information, but they don't tell you that you have to do it in a certain format, or whether it has to be paper or laminated or electronic. But there are some more recent Department of Labor opinion letters and also court cases where employers have sent the notices to their home-based employees or their off-site employees electronically, and the courts have said, yes, that is a good alternative. It satisfies the requirement. It makes sense. You got the notices to the employees. That's the intent, and that's what counts. So to help our customers comply, we've developed Postregard e-service for remote workers. And this is really, like I said, it's not a substitute for wall postings if you have a facility where your employees report to work. But for off-site employees, for employees who have internet access and who have either computers or mobile devices where they can access email for work, this is a fully compliant solution. And by the way, a lot of people ask me, at what point do you need to provide electronic postings to someone who works off-site? Like, what if they visit the office a few times a year or quarterly, and they see the posters on the walls when they visit in person? Is that enough? And the Department of Labor has recently provided some guidance on this, saying if an employee visits your facility with the physical wall posters displayed properly at your facility, if they visit less than 3 to 4 times a month, then you do need another solution to provide the postings to them. And the DOL specifically mentions electronic postings as a way to satisfy the requirements. So if you have workers who report into your physical facilities with the posters less frequently than 3 to 4 times a month, you do need to make sure you're getting the notices to them some other way. So this is the way the Postregard e-service for remote workers works. You provide the email addresses and zip codes to us of the remote workers, and then we pretty much take it from there to communicate everything and keep you in full compliance. We start out by sending a welcome email to the off-site employee, and the email has simple instructions, letting the employee know, you need to click and view these mandatory labor law posters. And then when the employee clicks on the posters to view, it automatically is saved as an acknowledgement with the time and the date when the posters were viewed, with the employee's name and everything. We host all the images Postregard hosts all the images, and our legal team makes sure that they're always up to date and fully compliant. That initial email communication goes out to the employee right when they're first signed up. So it happens upon enrollment where they're required to view the posters. And then whenever there's a mandatory change affecting that employee, we automatically send another email with the same instructions, letting the employee know the posters have changed, it's mandatory, you're required to click here and view the updated posters. And all of that is saved again as an acknowledgement. Then the employee can always go back in on their own. They just sign in with their email address, and they can view the current posters anytime just by signing in 24/7. So this is really great because it provides full tracking of all the dates and times when your employees acknowledge the posters. So, it actually shows up on our members-only web portal on postregard.com. Right there along with your other shipping and delivery information. So just as you can see when a physical package arrives at your locations, you can also see an employee's name and date and time when the off-site employees have viewed and acknowledged the electronic posters. So this is really useful. I can tell you from experience defending employment law claims, and it usually happens with policies, handbook policies. But employees will always say, I didn't know about that rule, or I didn't get that memo, I didn't see that update, no one told me. So in this case, you have the proof and the tracking for backup. You have everything you need to show that the employee did, in fact, view and acknowledge all the postings as required. And by the way, the remote employee automatically gets access to all the posters they need for their city or county, too. So it's federal, state, and local, and it's all based on the zip code that you provide. And then, of course, you can add additional postings if you need to, like federal contractor postings that we went over. The point is just to make sure that these employees have access to the same information that is required to be posted on your walls. Okay, and finally, we're just going to touch briefly on this last one, and that's applicant area postings. And this is an area of compliance that a lot of people are just not that familiar with. And it's always surprising to me because, it's really important because if you were to have some kind of audit, an inspection officer or someone that comes in, they really don't have to go that far to see if you're in compliance when it comes to applicant area postings. So a lot of employers don't realize this, but out of the 6 mandatory federal postings that we went over, 4 of them have to be displayed in an area where applicants can view them. And those are the EEOC posting, FMLA, USERRA, and EPPA. So Postregard has developed 2 different solutions to help you comply at your physical facilities. So if you have any areas where you allow applicants to come in, whether it's to fill out an application or if you conduct interviews or pre-employment testing, if there's a physical area where applicants are invited to come in, the 4 postings are required. So the first option that we offer is sort of a smaller vinyl adhesive peel-off sticker, and this is more compact, and it just has the 4 mandatory postings. It's ideal for like the little applicant kiosks or desks if you have areas set up with computers or other small areas for applicants to come in and apply online or take a paper application. Anytime there's a dedicated applicant area or even a desk that you've provided for employees to sit down and fill out for prospective employees to sit down and fill out an application. And then the other option is just a little bigger. It's more comprehensive. It's full size. It's laminated. It has the 4 mandatory postings and then 2 additional best practice notices based on customer request. One just informs applicants that you comply with immigration laws and I-9 requirements, and the other notifies applicants that you're a drug-free workplace. So this is more ideal for if you have like a dedicated applicant area or an interview room or even in your HR area. And don't forget, by the way, that you need to make sure you're providing these postings for online job applicants as well. So these are also available in an electronic format, so you can just add that link to your existing online application platform or whatever you're using for that. Well, that wraps it up. I hope you found this presentation to be helpful and informative. I know we went over a lot of legal requirements and details. especially around liability, but there's a lot to share when it comes to these laws and the risks of noncompliance. If you have any questions or would like additional information about Postregard or any of the compliance issues that I've talked about today, please feel free to contact our compliance specialist, Peter Frey, at 954-970-5702, or you can reach Peter by email at pfray, P-F-R-A-Y, at hrdirect.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.